All rise. The Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Welcome. This is Arizona Court of Appeals, cause number CACV 130510, Merkins versus Federal. Welcome to the Court of Appeals. For the party's information, these proceedings are being recorded. As you approach the podium, please identify yourself and who you are representing. Each side will have 20 minutes to present their argument. Appellant, if you wish to reserve a portion of your time for rebuttal, if you'll tell us at the beginning of your argument, we'll try not to horn in on all of your time. We have read the briefs and looked at relevant portions of the record and discussed the case in conference this morning. So we are aware of the facts and the issues. And then the clock on the podium in front of you indicates how much time you have remaining. Appellant, if the clock says 10 minutes and you want to reserve 5 for rebuttal, that 10-minute includes your 5 minutes of rebuttal. So with that, you may get started.
May it please the court, my name is John Wilborn on behalf of the appellant, Angela Merkins. This case turns on whether the appellant must request a hearing before filing her bad faith claim. It is the appellant's position that because of the existing case law does not require, and there is no case cited by either side that makes such a requirement, no such predicate, that in fact she is entitled to file her bad faith claim as soon as a breach occurs resulting in damages.
So as a matter of the fact, though, do you know why your client didn't fully pursue the matter before the commission?
She made a decision to file a bad faith claim because the law says she's entitled to.
Now, under the Industrial Commission, when a person is injured, you can either sue your employer and related parties, or you can go through the Industrial Commission for compensation for however long that may take, and in some cases, 10, 20 years, depending upon the nature of the injury. We had one last week. There was a brain injury. We've been dealing with it or he's been dealing with it for a very long time. How do you anticipate, if this were to go to a jury determining whether or not your client had either still a temporary total disability or a permanent total disability because she still hasn't, really had not opted out of the Industrial Commission process?
Well, Your Honor, I believe, first of all, that the damages as posed would be the damages subject to the bad faith jury instruction, that she would be entitled to all those damages as a consequence of the breach, and that they would be calculated in that manner. There would be arguments on both sides, one attempting to maximize the damages, one attempting to minimize the damages. And the bad faith jury instruction does not use the terms that would be synonymous with a workers' compensation award.
Well, it would be the unpaid benefits of the policy, and you would think you would also be claiming that emotional distress, humiliation, inconvenience, and the rest. But I'm trying to formulate how one would instruct the jury about what are the unpaid benefits of the policy?
The unpaid benefits of the policy would be those benefits that are derived from the policy itself. Now, in this case, the policy specifically cites to the workers' compensation statutes in a given jurisdiction as controlling the limits to be considered for those damages arising from the policy.
I think the problem that at least that I'm having is that we don't know whether she would have even qualified for further benefits because she didn't finish up. And it seems to me that before you can claim that the insurance company acted in bad faith, that you have to have in a workman's comp case, you have to at least show that she would have qualified for the benefits. They terminated the temporary total disability and the benefits she was receiving, and she never pursued that. So how, I guess, talk to us about how you think that, I mean, how does the jury determine that when those are specifically issues that are left for the Industrial Commission?
Well, Your Honor, the Boy case specifically states, or relies on the Savio case out of Colorado, that the duty of good faith and fair dealing precedes any hearing or any decision by the ICA. That is, that the duty of good faith and fair dealing attaches as soon as a claim is made. And so if the breach occurs, and the breach includes a denial of benefits, and there is no case that says if the insurance company denies benefits in a workers' compensation case, you can't have bad faith. There's no case that says that.
And I don't think there'll ever be one, except that the bad faith, well, whether federal would get away with what they had been doing to your client could be resolved by the Industrial Commission, who could say, hey, she's still injured, you've sent her to, bad IMEs, and, you've made a poor decision, so continue. And then she would still have additional bad faith claims.
Yes, Your Honor. But because of the case law, and if you look at the Hayes case talks about concurrent jurisdiction. The Boy case talks about how the duty of good faith precedes any ICA award, any ICA decision. If you take that to its logical conclusion, you have to agree that once a bad faith breach arises from a denial of benefits, the denial of benefits becomes the causation for the damages. And the issue in this case is not what the damages are, it's how did they occur. In this case, the appellant was receiving benefits for several months. In the record, the ER physician diagnosed injury, the treating physician diagnosed injury, the opinion of Dr. Silverthorne in January diagnosed injury. There are 3 doctors who actually saw the patient who diagnosed injury. That wasn't good enough for the insurance company. They asked for another IME. Now, presumably, they had done so to satisfy the issue of whether or not she was entitled to an open lung biopsy, which is, by all standards, a dangerous way to find out what her condition is. But the result of that was more than what was necessary. That is the direct act. The damages are a consequence of that act. It's a new claim.
But what would your damages be if for example, your client had gone through the workman's comp process, had finished it out, and the ALJ had determined your client was entitled to anything else. What the insurance company had done up to that point was fine. In other words, that she didn't have any more, that there were no more lung problems, that she was fine, she could go back to work. What would your damages then be? You see, I feel like we're missing a part here, so.
We're really not, Your Honor. Like I said before, the reason why we're focused on damages is because that's where the appellee wants to go with the argument, and did so successfully at the trial court level. But the issue is not, and if you look at all the case law that's cited by the appellant, the issue with regards to the duty of good faith and fair dealing and the breach and the consequences of that breach are measured by the damages that occur as a result of the breach. And if there's concurrent jurisdiction, and if we have an intentional tort by a third party, concurrent jurisdiction tells me she has the right to go in either forum and ask for those damages.
I think Mendoza seems, at least the way I read Mendoza, seems to say that you're entitled to those damages that are not the result of the work injury.
Yes.
And so, what you're claiming are the work injuries for damages. You're not, because Mendoza says you can claim pain and suffering, you can claim emotional distress. Those are not things that you're going to get in a workman's comp claim. You cannot get the benefits that were due under the workman's comp claim, but you can get the benefits that were not, that you can't claim under the workman's comp, like emotional distress, that kind of thing. You know, if the denial of the benefits had made the lungs the lung condition more serious, that's something that could be gotten in a bad faith claim. But it seems to me that what you're asking for are the workplace injury damages.
And that's what the appellee is asking the court to agree with.
Well, I got to tell you, I've read through the pleadings. I looked at your first amended complaint, and I've looked at the statement of facts where you do say that's what you're asking for. I don't see that you're asking for emotional distress. I don't see where you're asking for any of those other issues, any of those other claims.
No, Your Honor, and the decision was one that I dealt with my client with regards to how we framed the argument. But that presumes the position that we're taking is that you calculate the damages the same way, but that doesn't make them the same damages. That doesn't mean.
Tell me what you're saying.
Because the damages are caused by something different. Like I said before, she was receiving benefits. She stopped receiving benefits as a result of, according to our position, of bad faith conduct. Assuming that you look at that evidence in light most favorable to the appellant, what we're looking at is an act which causes damage. That's the crux of the case.
Okay.
The question is, how do you support that position? The Boy case says that the duty of good faith and fair dealing precedes even a final award. And in that case, the claimant did not file a request for J hearing, and the insurance company took advantage of it. There was no decision. There was a denial of benefits. And that denial of benefits is the damages that were caused by the bad faith conduct. Those denial of benefits that had been agreed to. The other position that you have to take a look at is how you come to the conclusion that exclusive jurisdiction applies to damages in this case. And the only way you can do that is if you decide that the Sandoval decision applies to bad faith cases. The Sandoval decision was specifically distinguished in the Franks case. And it was distinguished by saying that it doesn't apply to bad faith cases. It doesn't get more square than that, Your Honors, that you can't use the Sandoval decision in a bad faith case because this court said it doesn't apply to bad faith cases. Yet the trial court relied wholly on that case and a couple of other cases that dealt with jurisdictional issues in order to come to the conclusion that it didn't have jurisdiction to decide the issues in this case. And I see that I only have about 5 minutes left, and I'd like to reserve. There is an issue for cross appeal, and so I'll have to address that if
Okay.
the
Thank you.
appellee does so. Thank you.
And because I forgot there was a cross appeal, you get the final word. If you want to reserve any portion of your time for your cross appeal, you tell us that as well. Okay.
Thank you, Your Honor. May it please the court, my name is Kevin Meyer. With me is Jay Laughlin from the firm of Broning, Oberg, Woods, and Wilson. We represent federal insurance in this case. We are the appellee and the cross appellant. The Superior Court's grant of summary judgment in this case was correct for two reasons. One, plaintiff failed to make any distinct bad faith damages, any distinction between the bad faith damages she suffered as a result of the denial of benefits versus her claims that she attributes to the industrial industry. And the second reason is that the exhaustion of remedies doctrine applies in this case, and her failure to request a J hearing should preclude her claim.
Well, is it really an exhaustion so much as, the Constitution and the statute has said for workplace injuries you get, unless you opt out, you're limited to comp. And so that statute may be work as a preclusive impact, at least as to damages related to the workplace injury.
Yes, I think there are a couple of different labels we could apply. I mean, to the extent that you're actually talking more about an election of remedies, either choosing to go after the employer or you're actually seeking the benefits provided by the workers' compensation carrier, then once you've elected, you have to maintain that. And it's very clear that a J hearing requires you to challenge the denial of benefits within 90 days. Benefits were paid for several months in this case. There was a denial of benefits, and as we're hearing here today, plaintiff made an election not to pursue that. But I think the Sandoval case is very clear that you have to actually get an ICA determination for the reasons that we've talked about. The ICA system is this trade-off system by which employers are allowed to have worker compensation carriers pay for these benefits in exchange for certain types of agreements on causation and determinations. And we also have the ALJ system, judges who are trained in the very specific statutes and regulations that apply to workers' compensation carriers, and who are also trained in hearing this type of medical evidence and who understand the terms like stationary and impairment rating and those sorts of things. That's the system that we have. And I know that there are some concerns that we have about how the jury system would try to handle these cases. If anyone could simply say, you denied my benefits, even on a temporary basis, therefore it's bad faith, therefore I get to go to the jury. It completely upends this system, and it's a problem, and the legislature saw fit to create this system, and that's the system that should be followed.
Couldn't Ms. Perkins still pursue any other damages she might have with respect to the bad faith claim?
We agree that bad faith is a separate claim and that it does not have to go through that process if there are separate damages related to the actual denial of benefits. But what the trial court focused on correctly is that there was a failure, I think, to even allege separate damages, let alone prove separate damages. And I think you have repeated instances, both in the trial court and on appeal, in which plaintiff is confirming that she is seeking all of the damages that she believes are flowing as a result of the industrial industry. Record 67 on page 3 is her response to the statement of facts, and she confirms plaintiff is tying all of her damages to the denial of benefits. And the trial court tried to suss this out and see if there was a distinction. But there isn't. There isn't a separate claim for emotional damages. There isn't something separate and apart from the industrial industry that she's claiming. And again, we heard today that the denial of benefits becomes the cause. That's not what the system was set up for, as this court noted in Mendoza. You're not allowed to get the damages resulting from the industry. You're getting the workers' compensation benefits, and that's what she should have been limited to. And her failure to plead and ultimately failure to prove that there were separate and distinct damages is a reason that the trial court granted summary judgment and is a reason to affirm.
Now, is the insurance company stuck with the benefit amount that the commission determines if there is a separate bad faith lawsuit?
Well, I mean, certainly, if the claimant goes through the process and actually asks for the hearing, both the claimant and the carrier would have a right of appeal to this court, technically through a special action, but it would be designated as an ICA appeal. In fact, in the Mendoza case, the ALJ actually found bad faith. And so it's not as if those remedies can't be pursued and there can't be those determinations. So the claimant is protected and has rights of review, as with the carrier. And I think it would just depend on the facts of the case and what the positions of both parties were. But there is a system set up for this. Again, in the Boyd case, yes, Judge.
I was going to say, at least in looking at the complaint, it looks like, maybe I'll have to go and re-review the court's ruling, but it looks like for all consequential damages and general damages, which suggests at least, even if we were to decide to carve out the unpaid benefits, there could be, the emotional trauma of how Federal handled the claim.
At the time of summary judgment, there isn't evidence that was put forth. There isn't evidence, to my understanding, identified by the plaintiff as to where that emotional benefit claim was actually made in terms of proof at the time of summary judgment. And that certainly is a failure. And on that basis alone, this court can affirm. Just go back to the Boyd case. I mean, certainly we recognize and the law is clear that there can be separate things that would actually result in a bad faith claim against an insurer. The Boyd case talks about this in relation to the Colorado case that's cited by a lot of these cases, especially if you had a workers' compensation carrier that is slow paying a claimant, trying to take a position and straddle and say that one claim precludes payment on another claim. And that would certainly be a case of bad faith that should be brought in Superior Court, and that's fine. But what Sandoval's talking about is when all the allegation is, and I submit that all of the allegations about doctor shopping or anything else, or intrusive IMEs, which again, as we pointed out in our brief, were actually required by the appellant's pulmonologist. If all you're complaining about is the denial of benefits, then that's just a straightforward J hearing, and that's what should have been asked for in this case. I'll speak really briefly about the attorney's fees issue.
Well, Mr. Wilborn made the point that if we look at just straight bad faith law, shouldn't these benefits flow from that? Because currently there seems, as he's suggesting, a gap in at least the case law with respect to that, other than the preclusive nature of the statute.
I think it's a bad idea to compare general liability policy benefits and bad faith claims based on that with what's going on with the Industrial Commission. And I think this is the question that Judge Orozco was asking. How do we know how much in terms of benefits this person was entitled to if they don't go through the ICA process? It's not as if they can demand policy limits and just pay a certain amount. So this idea of we're entitled to all the damages really just is a concept that doesn't fit well with the workers' compensation system, because it is different. I mean, it obviously is an insurance system, but it's regulated and governed by the Industrial Commission and the rules and the promulgations that go with that. So I think it's not quite the straightforward application that's being suggested by appellant.
And I suspect the employer's policy with federal cites to the statutory framework and what they may or may not have to pay.
Yeah, Your Honor, I don't believe that's in the record, and I would assume it is. I can't speak to that directly. So
I don't want you to go beyond the record.
thank you. Very briefly, I'm sorry, Judge.
Before you move on to the attorney's fees, I have a question, and I should have asked appellate's counsel as well. It seems that the MSJ only dealt with bad faith, and there was also a claim for breach of contract. Did the breach of contract, what happened to that claim?
That was dropped, and I'll let plaintiff speak more to that.
Okay.
Really quickly, with respect to the fees, we applied for fees. On page 16 of the reply brief, plaintiff concedes that this is a proper case for 340-101. So really what we have is just the trial court's determination that the hardship factor from Warner outweighed everything out, all other factors. And again, I think if you look at this, when you talk about the merits of this case, when you talk about cases like Mendoza and Sandoval, I think it was fairly clear that they were supposed to follow the J proceeding. It was a fairly clear case in that respect. To the extent that plaintiff wants to argue that they were successful on removal and the motion to dismiss, those are procedural things, not a substantive basis. To the extent that this could have been avoided, there were multiple offers of judgment and chances to settle. We can see that there's a hardship difference. We recognize that the trial court had a basis to find that. But plaintiff concedes that we prevailed. And I think given the nature of this, given the fact that there is a system set up to limit the exposure and risk of workers' compensation carriers, and that we need workers' compensation carriers to participate in the system, it's important to impose fees in this case.
Well, how would we get, as you've just acknowledged, the fact that there's a basis for the hardship? How do we say that's an abuse of discretion despite the fact of the rest of your argument?
I think a proper weighing of the Warner factors in light of the policy considerations we're talking about in this case.
We don't do that. That's, at best, you're asking us to remand that to the trial court to do. We don't independently, determine those factors. Would that be as a policy matter, a beneficial way to handle this case?
We would request that relief then.
Okay.
Thank you, unless there are further questions.
No.
Thank you, Your Honors. First of all, with regards to the attorney's fees, the abuse of discretion standard, the discretion given the trial court is broad, it's substantial, and there is not one case that requires the weighing of all the factors to consider. The trial court is asked to look at those factors, and I think Warner versus Indemnity might even have said that's not exhaustive. There might be other factors. But in this case, we have a person who's on Social Security who doesn't have the ability, given her physical condition, to make any money, and is living only out of the grace of her parents. I think given that the cost shifting requirements under 12341 require that discretion be made or decided with regard to that factor alone is sufficient and not an abuse of discretion. But in our moving papers, we also argued that not all of the factors weighed in the appellee's favor, that there are in the moving papers solid positions with regards to the other factors. And that being the case, even if both arguments are valid, I don't think that the trial judge abused the discretion. To clear up the issue of the breach of contract, Your Honor, it was dropped. I don't know if we filed anything specifically or not, and if we didn't, I can tell you that it would not be something that we would bring up to the Court of Appeals in any event.
We just noticed that, because I think Judge Roscoe noticed that it was contained within the judgment. He said, "How
The
did that-"
judgment was in Federal's favor with respect to liability and damages in this case, which seems to, and then, or the judgment says it dismissed all claims. And so it sounds like it was dismissed. It just, it was nobody talked about the breach of contract, so,
No, and
okay, that's fine.
that was intentional, Your Honor. With regards to the damages and the issue that the court is wrestling with today, the statute 23-1022 limits the jurisdiction to those injuries that arise out of and occur in the course of employment. All of the cases talk about the damages that arise out of the breach of the duty of good faith and fair dealing are not arising out of or in the course of employment. And if those damages include damages that arise from the contract, then the logical conclusion is that it's not the exclusive remedy with regards to those damages. And exclusive remedy in and of itself within this statutory concept has been severely limited by Franks and its progeny to the point that those damages can be sought in either jurisdiction. It is only the appellee's contention that certain types of damages are the exclusive remedy of the ICA. And with regard to the specialization argument, Your Honors, I find that a little bit disingenuous, because the trial judge has the instructions, there are experts, and workers' compensation cases go to jury trials every day, and they have to hear evidence on impairment ratings from experts and what a proper method of resolving the workers' compensation issues would be. And that happens in jury cases all the time. So to say that the impairment rating would be within the special purview of the ALJ, I think isn't a good basis to rely on upholding the decision. I would, in closing, Your Honors, I would just ask that you seriously consider where these damages arise from before you make your decision. Thank you.
Thank you, counsel. We will take this matter under advisement and issue a ruling in due course. I forgot to mention that while these proceedings are being recorded, they also are being audioly and visually recorded, and hopefully, in due course, you'll be able to see yourself on YouTube. 20 minutes of fame. So, with that, as I said, we'll take the matter under advisement, issue a ruling in due course. We're going to stay up here and let the parties, this argument leave and have the next one come up.